Hey everyone, Attorney Eric Ramos here. Today I'm going to answer the question, what is the difference between expungement and an order of non-disclosure? So these are very similar procedures with very similar outcomes, except for expungement, at least in my mind, is a little bit better than an order of non-disclosure. So both of these things are forms of what's called post-conviction relief, or ways to seal or destroy your criminal record. Now, an expungement actually destroys the criminal record. So when the judge orders an expungement or expunction, then state agencies and people who have copies, or if they have any information about that criminal record, they're ordered to completely destroy it. Now, non-disclosure, on the other hand, is sealing the criminal record. So they have to seal it so that when private parties do background checks, for instance, your employer or future employer, even friends or family or lenders, anyone looking for a background check on you, they will have no idea that that charge ever happened. The only people who can see a sealed charge are entities like state entities, like the police department, law enforcement, certain state agencies that may need to have that information if you're applying to become a lawyer or a doctor or a nurse or for certain professional licenses. The good thing is, even with a charge like a single charge on your record that may not hold you back, it's always better to have it sealed because it shows that you took steps to take care of it. So record sealing or non-disclosure is a really good option. Now, why would someone go for non-disclosure versus expungement? The answer there is simple. Non-disclosure and expungement are available to different sets of people, and these remedies depend on the outcome of your case. So expungement is only available to a small group of people who had their charges either completely dismissed for particular reasons, or they completed pretrial diversion and had it dismissed that way, or if they went to trial and the jury or the judge found them not guilty, and that's called an acquittal. Now, for non-disclosure, that's open to a much wider range of people with a much wider range of outcomes. So if you did something called deferred adjudication and you had your case dismissed at the end, then non-disclosure should be available to you as long as you meet certain other requirements. We do a lot of non-disclosures for people who got deferred adjudication. Another way to get a non-disclosure is if you were placed on probation and you successfully completed it. Now, even people who were convicted, meaning they actually were found guilty of certain offenses, usually non-violent, non-sexual offenses, in some of those cases, they can seal the records. So things like theft or drug possession, other things that are non-violent and not family violence related or have any kind of what the state calls sexual offenses, a lot of those things can actually be sealed. And for most people, and most people looking into their record, it's like it never even happened. So expungement and non-disclosure are very similar, and they're only different in who can get an expungement or non-disclosure based on the outcome of their case. So if you have any questions, or if you're wanting to know if you're eligible for one or the other, you can take our free online eligibility test. If you're not sure about the results of your case, and you don't know what to plug into the test, give us a call. We can look into it for you, help you determine whether expungement or non-disclosure is right for you.